I'd now like to welcome the following representatives from the Queensland Human Rights Commissioner, Neroli Holmes and Bree Callaghan. Neroli's the Deputy Commissioner and Bree's the Senior Lawyer. Good morning and thank you for being here. I invite you to make an opening statement of about 5 minutes, and after that the committee will have some questions for you.
Thank you, Chair. Good morning, everyone. Before starting, can I acknowledge the traditional owners of the land on which we meet today and pay respects to elders past, present and emerging. The Queensland Human Rights Commission supports the passage of the Births, Deaths and Marriages Registration Bill 2022. The bill delivers reforms which are essential to ensure the privacy, freedom of expression and equality before the law of people accessing Queensland's birth registration system, and in particular, trans and gender diverse people and diverse families, including same-sex families or same-sex parent families. So in relation to changing the record of sex, ensuring fair and equitable access for transgender and gender diverse people to change their record of sex upholds rights protected by the Human Rights Act, the right to recognition and equality, and the right to privacy. As stipulated in the Yogyakarta Principles, people of diverse gender identities should be able to enjoy legal capacity in all aspects of life without the need for surgery, hormone treatment or sterilisation as a prerequisite of legal recognition. The benefits of these reforms will ensure a person can engage with society in a way that limits exposure to stigma and discrimination and improves their participation in areas of public life, including work and education. The reforms modernise the law, align Queensland's laws with the most other Australian jurisdictions and address potential human rights incompatibility in the current legislation. With relation to modern family and parenting structures, ensuring the parents recorded on a child's birth certificate can be registered as mother, father or parent promotes the right to protection of families as a fundamental unit in society. Currently, only one parent may be listed as mother or father, which does not reflect the diversity of contemporary parenting arrangements, including same-sex parented families. The current definition of birth also means that those who do not identify as a mother, including trans or gender diverse birth parents, must be registered in a role that does not match their identity or the way in which they present to the community. The approach in the bill provides better recognition of all kinds of families in line with Queensland's human rights obligations. We do have a couple of small recommendations in relation to the bill. We think that the bill should be passed subject to the following. Following the passage of the bill, an audit of Queensland legislation should be completed to identify occurrences of terms sex, gender, and other gender-specific language such as woman, man, sister and father to ensure equal recognition and treatment of trans, gender diverse and intersex people in all Queensland laws. And that's something that's currently happening in other states, including Tasmania. And we do think it would be appropriate for the committee to seek some clarification from Queensland Corrective Services about why the approval process for change of sex for restricted persons is necessary and justifiable, and how these provisions will work in practice. That's outlined a little bit more detail in our submission. But thank you for the opportunity to speak to the committee today. That's our opening presentation.
Thank you. Laura?
Thanks, Chair. I'm going to pass to John just so that we get a question. Okay. So, pardon? There you go. I just know we're short on time and we're a bit truncated, so I just want to make sure all the committee members get a chance. So in your submission, you raise a query in relation to anatomical capacity and the explanatory notes reference to anatomical capacity. And I'm wondering if you can just elaborate on that for us. And did you happen to get a chance, I know it was submitted only last week, but did you happen to get a chance to have a look at DJAG's response?
No, we haven't had a chance to look at DJAG's response yet, so unfortunately. Look, it was just trying to understand how that provision would work. And so that was our query, and we thought that was appropriate for the committee. If you were seeking clarification yourselves, get that clarification. So unfortunately, we haven't had a look at DJAG's response, but I think it's elaborated in our submission. Yeah,
I'll leave it there then. I'll give you some time to look at it.
Yeah. John?
I'm okay at the moment, Chair.
Yeah. Sandy? I didn't
Thank you,
forget
Chair.
this time.
Good morning, Nerily. Look,
morning.
in your submission on page 5, you state that the bill will ensure the birth register contains information that is accurate and complete as possible. However, Adoptee Rights Australia argue that aligning birth certificates to the lived identity of social parents denies the genetic truth of the child at birth. Do you have a view on how this can be addressed?
So I'm not quite sure what the argument is there. Can you maybe explain it a little bit more? What they're saying, that an adopted child, is it, or adopted parent?
Basically saying that yes, that the birth certificate, aligning it to the lived identity of the social parent, so if it's changed, denies the genetic truth of the child at birth. So they're basically, saying that the genetic truth won't be available to them if these changes go through. My question is, how do you see this can be addressed within this bill? Because ultimately it doesn't.
So they're trying to trace back their genealogical record. Is that what they're trying to do?
Yes, they want to retain the genealogical record
and trying to work out where their ancestors, etc., doing a family tree or something like that. Is that
yes.
the proposition?
Yes. Yeah, basically yes. If suddenly we change from having mother, father, and also whether somebody, how they identify as in, if the birth certificate has changed from, female to male or vice versa, that the actual genetic truth of who they are can be lost. And so if this bill is to go through, how then will it be addressed?
I don't actually know if birth certificates ever have been a source of genetic truth, to be honest with you. I think the people that are listed on birth certificates are ostensibly who you understand your parents to be, but I think we'd find in the historical record that is not always an accurate record, that often you can find out, and I think there's plenty of examples around at the moment with people doing those genetic searches that reveal, there's a bit of a surprise in the family tree that you think your birth certificate says something and it can actually not be reflective of who your genetic origins might be. So I don't know if it's ever been an accurate record, and I actually don't know if it's a real problem. I guess if I'm trying to understand where the issue is coming from, you're trying to understand who your birth parents are. I think the record will show that to a degree, but I think it would be a question to put to the Registrar of Births, Deaths and Marriages, or DJAG, for that intricate questioning. But I wonder if the birth record's ever been as accurate as people would hope and wish it had been.
All right, thank you.
John D.
Thanks, Chair. Good morning, Nerily and Bree. Nerily, I'm interested in your recommendation for around doing a comprehensive audit of the current ledge. You've mentioned Tasmania went that way. I just wondered if you could speak to that a little bit more and the benefits of that. And obviously Tasmania and Queensland are quite different states, how that would actually, whether that would work here.
Yeah. Well, I think, the legislation record is quite old. All our pieces of legislation in Queensland have been passed over many generations in times before we had a more nuanced understanding of sex and gender. So throughout the legislative record, there will be a whole list of terms that are both gendered and sex-based terms. So if you go through the record, it may be appropriate to check where those names are listed or those terms are listed, to reflect with modern and contemporary understanding of these issues. Is that legislative record still working the way it should be? Should those terms be amended or changed to reflect what was intended in that legislation and to reflect the new realities of and understandings that we have. So I haven't been through the legislative record, but I'm sure there's lots of instances, possibly in Succession Law or the Property Law Act or the Health Act or myriads of other acts where there's boy, girl, brother, sister, mother, father, female, male. There will be multiple occasions where these terms were interchangeable and understandable at the time, but when we've got a more nuanced understanding of sex and gender, that it might be appropriate to go through to make sure that the legislative intent is still clear in those records, those statutes.
Thank you.
Can I come? Laura?
No, I have no further questions. Thank you.
John? Sandy?
It's just a last question, Nerily. Just, when we're speaking about the volume of aspects that need to be looked at, whether it's in legislation, whether it's to do with, records, police, it's very extensive. And has there been any estimate, because I haven't seen any in any of either DJAG or submissions, regarding what volume we're talking about should this bill go through, the work and how many years to change not only the differentiation between sex and gender, but to make sure there is no unintended consequences that we often see.
Look, I don't actually know myself. That would again be a question for DJAG or Parliamentary Council. I imagine it would be a not small task, but a task that could be systematically and appropriately dealt with over a period of time as each piece of legislation is renewed. It could be re-looked at. It could be that could be checked, but there could be also a project to go through and systematically have a look at the legislative legislation books and make sure they're updated.
All right, thank you.
Yeah, I'll take one. Ms Holmes, thank you for submitting to us this morning. In relation to the process by which people's birth certificates can be changed through statutory declaration accompanied by a supporting statement, and given the Human Rights Commission's role as sort of the safeguard of the Human Rights Act and the anti-discrimination laws in Queensland, and the impact of this bill being that anyone who changes their gender and sex on their birth certificate will benefit from all the rights in Queensland law. Have you given any consideration as to how the system has potential to be misused or abused by some parties, and what safeguards should be put in place for that, if any, given the Commission's role to safeguard everyone's human rights?
Yeah, and we do take that role very seriously. The changing of the record of a person's gender or sex through the birth certificate, we don't think will have a big impact on any of those issues. I know some submissions have said that. We've had the gender identity attribute in the Human Rights or the Anti-Discrimination Act since 2002, which has prohibited people discriminating against people on the basis of their gender identity, i.e. if they are a transgender person, in relation to all the things that we've got covered in the Act, so work, goods and services, education, etc. So we have had complaints made by transgender people when they've been discriminated against when trying to access services or go about their business, get work. So the protection for the transgender people has already been in the bill since 2002, but they still have had the problem of their birth certificate not reflecting who they are. And we haven't experienced any problems with, that have been suggested by people that, transgender, a male to female person is inappropriately accessing a service. They've got the right to access services just like anybody else in society. So if they need a DV service, they should be able to access a DV service. If they need a health service, they should be able to access a health service. If they wish to go to school or work, just like everybody else, they've got the right to work. It hasn't caused a problem. Where people have felt the need to obtain an exemption, that has already been permitted under the Anti-Discrimination Act, and there is one example with the Women's Legal Service obtaining an exemption in relation to having only females work in the Women's Legal Service when dealing with victims of sexual assault. Now that means men can't work with women in the Women's Legal Service with victims of sexual assault, but it doesn't exclude transgender women from that service. And I don't think there's been any issue with that occurring. So we haven't seen any safety issues. A couple of submissions that I did read alluded to cases overseas, but in Queensland, as far as we're aware, there has been no issues in the 20 years since gender identity has been a recognised attribute under the Anti-Discrimination Act. And certainly if there was an issue arising, we would have identified it and tried to deal with it.
Sorry. Sandy?
One last quick question. Narrowly, you've just said that basically since 2002, within the Act, already those that, regarding their gender identity, haven't been discriminated against or you're unaware of. So if that's the case...
I said they have been discriminated against, but they haven't... There's been no examples of inappropriate accessing of services by people who have got malintent.
Okay, but I suppose what I'm asking, but they have already been accessing all services and you're unaware where they're being rejected except for that one case regarding male...
No, that's not what I said. Sorry. What I was saying is there's been plenty of cases of discrimination against people who are transgender, but there's been no instances of people complaining that transgender people are accessing services that they shouldn't be accessing. So people have been denied access to services and certainly have brought complaints to us, and there's been cases through the tribunals about that. It's still an ongoing problem, but cases where people have said this person shouldn't be accessing our services, it's inappropriate, it's wrong, this is not we haven't heard cases of that happening.
Wonderful. Thanks for that clarification, Nerily.
Yep.
John D?
Yeah, thank you, Chair. Narrowly or Bree, there have been some submitters that have inferred or stated that the bill has been rushed and without consultation. Given your significant role in Queensland in what you do, I just wondered if you could give us some background to this debate and this issue and the conversations that have been occurring in this space.
Well, I think the bill has been talked about for the last 10 years. So we've been making submissions about the Births, Deaths and Marriages Act since about 2010, I think. So it's been an ongoing discussion. It's been an ongoing source of quite a lot of angst for transgender people and same-sex parents to try and update the Births, Deaths and Marriages Act. So it's been a very long and extensive period of consultation across the whole community. I think our Commission has done at least 3 submissions to the Department of Justice about this issue over the years. So I think there's been an extremely long period of consultation leading up to this bill where many, many people have had an opportunity to try and put their point of view across to try and create the legislation that's necessary for the 21st century.
Thank you. And just to clarify, Queensland is one of the final jurisdictions looking at implementing this reform. Obviously, other states have gone before us.
Yeah, I think so. Queensland's following on behind quite a few of the other states that have already changed their Births, Deaths and Marriages Act.
Thank you.
Laura?
Oh, thank you, Chair. I just wanted to just clarify, whilst the subject matter of this debate has been extensively talked about, would you not agree that the actual drafting of this bill differs from previous consultation models and that the timeframe for which stakeholders had to be able to consider the actual clauses and content of this particular bill was quite short, and some stakeholders found it vastly too short to be able to adequately respond.
Yeah, I think that's not unique to this Birth, Deaths and Marriages Act. I think we've had a plethora of legislation come through over the New Year period that a lot of stakeholders are looking at and thinking we're trying to grapple with a lot of legislation. But the concepts, I think, in the bill have been discussed for a long time. I think every bill that comes before the committee always needs finessing and debating, and we're really glad the committee process allows that to occur. We would have liked longer for this one, but we would have liked longer for a couple of other bills before the Parliament at the moment. I think we're talking to you another one this afternoon and a couple more later this month. So there's been quite a raft of legislation that's coming through. So I don't think the Birth, Deaths and Marriages Act is unique in that regard.
Yeah. Yes. Ms Holmes, you mentioned just a couple of questions ago that you've been making submissions about this for some years. I think since 2010, you said.
It's in our bill, in our submission, 2010 or 2012, not quite sure of the date, but we've made at least 3 submissions previously.
Is it the Anti-Discrimination Commission before the Human Rights Commission? Okay. Yep. Just wanted to clarify that.
Okay. Unless anyone's got a question, I intend on inviting the next representative to give their submission. Is anyone from the committee got a question?
Thank you.
All right, thank you. Thank you for your attendance. Thank you for your written submission, and thank you for the work you do.
Thank you, committee.
Thank you.
I'd now like to call